Thanks, Emily, and good morning, everybody. Happy Thursday. Um, Speaking of Thursdays, on Thursday, July 2nd, Governor Cooper signed into law House Bill 118, in which the General Assembly granted broad sweeping civil immunity for businesses from COVID-19 infection claims. This immunity law arose from concerns that the initial law passed to protect businesses during the reopening did not go far enough. Again, good morning, everybody. I'm Ryan Nance with North Carolina's Electric Cooperatives based here in Raleigh, serving the whole state. I also serve on the NCEDA Board of Directors and have the honor of welcoming everyone today and introducing our guest speakers. As we do before every NCDA professional development event, want to thank our annual sponsors. Have a look at your screen. Emily should have that pulled up right there. You'll see the names and logos of everybody. Again, our sincere thanks go out to these very special organizations and their companies. Among the maze of difficult business issues set off by COVID-19, liability considerations are very near the top. Today's webinar discusses the scope of new immunity protections, who is entitled to them and when, and guidelines businesses must comply with in explaining protective measures taken to guard against transmission of the virus. With us today are two legal experts who've been very close to the issue since the onset of the pandemic over 6 months ago. First up, Chris Smith co-chairs the business litigation team at Smith Anderson Law Firm. He's a trial and appellant lawyer who counsels clients on strategic business issues. He manages large multi-party and multi-jurisdictional litigation projects and mission-critical projects. Chris both prosecutes and defends claims and advises business clients on risk management in a variety of areas. He also is involved in development of public policy issues affecting businesses. Chris serves on the management committee at Smith Anderson, a Raleigh-based firm renowned for its business law practice. Joining Chris is Ray Starling, General Counsel at North Carolina Chamber in Raleigh. He's also president of the NC Chamber Legal Institute. He sets litigation strategy for the Chamber, the NC Chamber Legal Institute, and its affiliates. Ray also leads the Chamber's public policy development efforts, assessing and advising on current and emerging laws, rulings, and regulations affecting the North Carolina Chamber and the state's business community. He manages public policy efforts for the Chamber, designing and implementing business advocacy strategies before the General Assembly and state regulatory bodies. This is important knowledge about a legal issue that's very relevant to the economic development community. We appreciate our experts sharing their unique knowledge with NCDA members and our guests. Again, thank you for joining, gentlemen. And with that, I'm going to let Ray kind of step in and maybe frame out today's discussion and provide a little bit more color for Chris. So with that, Ray, I'll hand the baton to you.
Well, thanks, Ryan. I appreciate both being here with the Economic Development Association, but also it's nice to be introduced with a guy that keeps the lights on. So thank you for that. And as I start, let me just set the stage first on a personal level by saying super organization, work in tandem with the Chamber. We appreciate what the economic development folks across the state do. Great leadership, well-staffed, a great board with great community leadership, and frankly, similar goals. And I think that's what brings us together today. You're going to hear a common theme across the Economic Development Association, as well as the Smith Anderson Law Firm, as well as the Chamber, because all of us believe that we want to maintain a competitive business climate in North Carolina that allows us to continue to recruit businesses and the families and individuals that work in those businesses and keep them in the state. With that, I would tell you that that is an important part of what every law firm should be about, but there is one law firm in particular that is particularly good at that here in Raleigh, and that's where Chris works at Smith Anderson. We all want our attorneys to have the substance and to understand the law, but what Chris, I think, does is brings not just super legal work to the table, but also an awareness of this political and policy atmosphere in which we operate. I'm fairly certain that if I were to ask the members of the Economic Development Association, it's important to know what the programs are, but it's also important to know the politics. All of you would agree with that statement. And so what we're going to talk about today is how the law itself, how the substance of House Bill 118 works, but also a little bit of color on how it actually came together from a policy perspective and a political perspective. And so, Chris, I appreciate the chance to co-present with you. Look forward to, again, benefiting from your analysis of this. And again, to Ryan, to you, and to the great staff at NCEDA, thank you for having us, and we look forward to chatting.
That's great, Ray. Thanks so much. And thanks again also to Ryan and to NCADA. And it really is a wonderful partnership amongst our firm, the Chamber, and NCEDA. You know, it's always a pleasure for me working with my good friend, Ray Starling. One thing that that I'd like to mention, we work closely with the Chamber on the executive committee at the North Carolina Chamber. Ray is our general counsel for the Chamber. So, you know, I'm actually relying on a lot of his advice here today as we talk through this. And Ray and I serve together on the Chamber Legal Institute, which he is the president of, and I also serve on that board. So all those things really sort of came together for this discussion here today on H118. Emily, if we could go to the next slide, please. Yeah, so what we're going to get through today, how this all came together. And, you know, everybody is working hard and in good faith. And this audience, I think in particular, appreciates how essential it is that we keep the engine of the state running while taking care of each other. And striking that balance, as both Ryan and Ray mentioned, is what H118 is all about. Striking that balance so that the engine of the state can keep going forward, but we're all taking good care of each other at the same time. And you'll see how, you know, the concern that we didn't quite have that balance right, how those forces came together to try and strike what we think is a really good measure of how to keep the state moving forward, but at the same time, all of us doing what we need to do, which is taking good care of each other. And I'll walk through how we came to H118 and then flip it over to Ray a little bit so he can talk about, you know, the coalition that came together, and the NC Chamber was a big part of that, as well as others who were very important to the General Assembly. And then after Ray goes through that, I'll get back with you and really kind of talk about the meat of the coconut, and do the lawyer stuff and explain what the liability protections are in H118, as well as the obligation that the General Assembly has put on all of us to provide notice of protective measures that we're taking, really to take care of each other and to make sure that we get that balance right. And as part of that discussion also, you know, we'll zero in on, okay, I think the General Assembly and the coalition of interests that Ray was a big part of helping to marshal, and the Chamber was a big part of helping to marshal that, I think they got it right. The next step is going to be making sure that the lawyers and the courts get it right. And you'll see what I mean about that when we get back to the meat of the coconut and the need for, you know, the courts to really do what the General Assembly, gosh, in the House, it was 109-7. What they really intend to have happen out there. Okay, so that's the overview, and let's dive in. Thanks for advancing the slide there. Let's dive into where we began. So May 2nd, 2020 seems like forever ago, and it really wasn't that long ago. And prior to Senate Bill 704, Senate Bill 704 is really sort of the first big swing that the General Assembly took at trying to get that balance right us taking care of each other, but making sure that the engine of the economy can keep going. And this bill was passed, I believe, and Ray can correct me later if I got this wrong, but I believe Senate Bill 704 was unanimous in both the Senate and the House. Well, this first good faith swing at dealing with, everybody knows how it seems this situation changes almost on a daily basis. This was the first big swing at trying to get that balance right. And let's take a look at how we did there. Let's go to the next slide, please. So Senate Bill 704 did really kind of came at the issue in kind of three ways. I've got two of them up there. I've left one off because the one that I've left off deals with providing protection to healthcare providers and facilities. The reason I've left that off is because really I think the consensus there is that the General Assembly nailed it and got it exactly right for healthcare providers and healthcare facilities. And basically what the law provided is that, for transmission cases, if somebody gets the bug, gets COVID-19, unless the healthcare provider or facility was grossly negligent, we're not going to hold them liable. We're going to excuse each other during this special time from making ordinary mistakes and common negligence mistakes, because we need those folks to be able to have confidence that they're going to be treated fairly when what they do during this crisis is evaluated down the road. And undoubtedly, we're going to be evaluating our actions that are happening now down the road for sure. And we're beginning that process now. But there's two other big important pieces of Senate Bill 704 that sought to provide that protection against claims arising out of catching the bug or transmitting the bug. And that is the attempt, the giving that protection except for actions of gross negligence to what the General Assembly dubbed emergency response entities. Well, what are those folks? Those are folks who, made the decision to try and make PPE, lab testing stuff, equipment that we need to respond to the crisis at hand. So a great example of that is Hanes Brands out in Forsyth County. They changed a number of their lines of clothing manufacture to crank out PPE and to crank out masks for all of us. We need that. We appreciate it. And the General Assembly recognized that by saying these folks are going to be okay and we're going to protect them unless they were grossly negligent. So far, so good. But then the other group is defined as essential businesses. Well, the General Assembly, in a really good example of the branches of government working together on this, back in May, the General Assembly said, okay, an essential business is an essential business as defined by the governor in his Executive Order 121. Well, y'all will remember that back in March is when the governor issued the first stay-at-home order, and that was Executive Order 121. And that listed a whole group of, a whole swath of the economy that within that order was defined as an essential business. But it also left out an awful lot. And even those folks in an earlier presentation of this, of H118, we gave a presentation to a group of businesses. And it was a wide-ranging group of businesses that were on the webinar. And we asked them, after describing what the definition of essential business was, did this cover you? Were you good with this under 704? And the polling data from that webinar showed that less than 50% of the businesses participating then thought that they were protected. And here's kind of a, an example of that. So with the governor's executive order, again, an example of everybody working in real time, dealing with issues of first impression, like everybody on this call is my law firm, the chamber, NCADA, everybody is responding in real time and doing their best to get it right. Well, that goes for the governor too, trying to articulate what are essential businesses. And in his executive order, he described educational institutions as essential businesses. Well, that sounds good. We all know those are essential institutions, essential businesses, but here's what the order said. And this is what the educational institutions were reading and maybe started to wonder a little bit. So it said, educational institutions, including public and private pre-K to 12 schools, colleges and universities, for purposes of facilitating remote learning, performing critical research, or performing essential functions. Well, that seems maybe a little bit limiting. And then further, provided that the social distancing requirements set forth below in this executive order are maintained to the greatest extent possible. So you can imagine, those of you, economic developers out there, to the greatest extent possible, that is just inviting lawyer courtroom analysis and kind of defeating the purpose of creating that certainty and that safety for those essential businesses trying to feel their way in good faith to get where we need to be. So that, I think, kind of sets the table for, there's a whole swath of the economy that was looking around saying, boy, I'm not sure how good we feel about this first swing at trying to get the balance right. And with that, I think we can head to the next slide and flip it back to Ray, who can talk about those folks coming together.
That's right, Chris. And I think the real takeaway there in some of Chris's comments is this was not complete, right? I mean, and in fact, I would tell you that the way the conversation got going about taking another bite at the apple on liability limitations was frankly, and I will tell you, having done public policy work now a long time, this rarely happens, right? We often go to our legislators and we have something we need help with. What happened after Senate Bill 704, we actually had some legislators that realized that was not enough, that the onslaught of risk in terms of economic carnage that could occur if folks were basically sued away from getting back to business, the protection was simply not enough. And so in telling you how it came together, I would tell you three things that were critical. One of those was, and always is, when you're doing something on Jones Street, you have to have legislative leadership. We were extraordinarily fortunate in this case because we had both a prominent member of the House and a prominent member of the Senate who frankly weren't talking to each other until we kind of brought them together. So I feel like we did that right, but they already knew they wanted to do something. They felt like the atmosphere was right to do something. And frankly, they knew substantively something needed to be done. And that's Representative Harry Warren in the House and Senator Paul Newton in the Senate. So we began a conversation with them, and it was clear that they were going to be able to work together, that they felt like the sentiment in both of their chambers was in a place across party lines, by the way, that they could do a bipartisan bill that would be successful, that would broaden the protections that Chris described in Senate 704. So they gave birth to House Bill 118. So that first element was you've got to have solid, respected legislative leadership. The second thing I think you have to have is you got to have realistic goals, right? I would say you've got to have focus and you've got to not be hyperbolic. The U.S. Chamber is now working on the federal side of this, and part of what they say is targeted, temporary, and timely. Chris and I would tell you that House Bill 118 meets all of those criteria. It is targeted. It is not more broad than it needs to be. It is temporary. Chris will talk about that, about how the protections in 118 actually do expire at some point. And it is timely. It was put in place, frankly, as one of the first 5 or 6 pieces of legislation across the country, and I would argue is the most comprehensive, yet most simple of those first few pieces across the country that have been enacted. For example, to drill down on that just a little bit more in terms of the targeted nature of it, we actually did have a conversation with those legislators along the lines of, this seems to be limited to transmission. What about people in the zone of risk, but who never actually transmit COVID? They could conceivably, if they worked with a creative plaintiff's attorney, they could come up with a claim. Maybe it's an emotional distress claim. Maybe it's lost wages because they cared for someone with COVID. And so they feel like they have a claim in their own right, even though the COVID patient may not under House Bill 118. And frankly, what we were told is that that just goes too far. It muddies the water. That's hopefully going to take care of itself. We want to get to the nub of this. We want to get something through that can be quickly approved and that everyone can agree on. So targeted, temporary, timely. So that's number 2. So first of all, legislative leadership. Second, focus and avoiding being hyperbolic, literally talking about the question at hand and only answering the question at hand. And then the third thing, and this is where Chris and his law firm and colleague Dana Simpson, along with some other trade groups and associations, it took a coalition, a broad, disciplined, and diverse coalition. To my knowledge, the North Carolina Chamber does not typically link arms with the independent and private university system to work on policy together. Now, maybe we need to, but in this case, that's exactly what happened. They worked with Chris's colleague at Smith Anderson. We worked with the retail merchants. We worked with the home builders. We worked with realtors. But there were a lot of people who agreed to hop on and off calls and figure out, do we have a problem anywhere? What's the best way to get this done? That diversity, I think, at the end of the day, strengthened our ask. It strengthened the final product, and frankly, is part of how it got done. We had a lot of people from a lot of different walks of industry and of economic contribution to the state who all said this is important to us. So I think Chris is now going to unpack. So what did that look like? What did the final product look like? He gets to tell you how the sausage actually looked when it got made.
Okay, all right. Well, so I was going to stay away from the sausage and say we're talking about the meat of the coconut here. And if we could get to the coconut, which is the next slide.
Chris, we often say legislation is not like making sausage. It's like making fine wine. So,
there you go.
That's a better way to think about it.
And I think there. Thanks, right? I think. I'm sorry. Did I miss something?
I was just saying, not always easy to get to the meat of the coconut sometimes.
Okay, that's all right. And well, let's take the fine wine, because I think that is. I understand there may be a couple of legislators on this webinar, and we are grateful for your very hard work on this. And you probably don't often get told that what you did might be like fine wine, but here I think what the General Assembly did in trying to, we heard about that polling where you've got less than 50% thought that they had the protection that they needed to be part of the critical engine to keep us going while taking care of each other. And so the General Assembly came back with H118, and I think really with 2 broad and very simple but elegant strokes. I think it gets to that fine wine comparison, the way the General Assembly came at this to try and make sure that we've got that balance correct, and that folks working hard in good faith will be protected as they try to keep the wheels spinning for us all, which we have to do. So here is the definition section of H118. And this is the first, what I think is, an elegant in its simplicity, broad stroke to address the issue, and to address the issue of that nearly 50% of the economy that thought, golly, we could be at risk here. What did the General Assembly do? They took the definition of person and went high and wide with it. And every individual comes within the scope of this legislation, and every legal business entity in North Carolina, you see that language at the end there, or any legal entity, every legal business entity in North Carolina comes within the scope of the definition of person. So that means you, I'm pointing at all of you, me, Ray, Ryan, we all are eligible for the liability protection provided by H118. And essentially, everybody in North Carolina except dogs and cats and birds and fishes, you're within the scope of this legislation. So that's the first broad and I think elegant in its simplicity stroke that the General Assembly did here with this legislation. Let's go to the next part of the coconut. Next slide. Okay. So this truly is the meat of the coconut here. And this is the extent of the protection that every one of us and every lawful business gets under H118. And it's basically any claim for contraction of COVID-19, you are protected. Every legal business entity in the state is protected unless you acted with gross negligence. So we have made that decision as a state that, to get through this together, we got to trust each other. We got to work together. And we've got to give people, the comfort that they're going to be treated fairly in the end analysis. And these H118, the two key liability provisions that we've just looked at, the definition section and what we're about to walk through here on gross negligence, that law passed 40-7 in the Senate and 109-7 in the House. That is, I think, a resounding statement by North Carolina about how we think as a state we ought to try and strike this balance. Okay, so gross negligence, what does that mean? Well, here's the, and I don't have any problem talking this way about my profession, but here's the lawyer blather, okay? Here's the lawyer blather on what it says in the cases. Wanton conduct done with conscious or reckless disregard for the rights and safety of others. What does that mean? In common sense, what does that mean? Well, you've got somebody, let's just take the individual, an individual who's got the bug and goes into the workplace. We're not going to protect her. We ought not. Somebody who's afraid they've got the bug but goes out into the workplace. We ought not to protect him either. That's kind of, or the employer who knows or has concern that his workforce is infected. That's not the kind of conduct that we're going to protect. I mean, the kind of conduct we're going to protect is, I think my law firm, I'm very proud of the response that we've done and how we're taking care of each other. And there is regular communication. There are strict rules about the 3 W's. If you come into the office, everyone who can work remotely is instructed to work remotely at present. But there are just rules of conduct that folks need in good faith to follow. And that's the kind of conduct that is solidly protected by the General Assembly here. So, you know, in common sense English, what we have done as a state.
Did we lose Chris, or is that just me, Ray?
Yeah, I lost his sound. His video looks really good, Chris, but if you're not on mute, it doesn't appear. You want to, but we can't hear you at the moment.
Yeah, you've dropped off, Chris. I think Chris might be making some adjustments on his computer.
And Chris, you could, of course, mute yourself and just dial in on your cell phone, and we would be able to hear you. Okay.
Yeah. All else fails, back to the cell phone.
Looks like he's getting called in. I think one thing he was doing a nice job setting up there, Ryan, was, you know, and maybe I'll sound a little flippant when I say this, but the line between gross negligence and negligence is a fine one, and it's typically one. Yes, you are. You saved it. Yes.
Hey, I'm sorry, folks, and thanks for the great instruction from the person out there in the audience to reboot. So I've rebooted. Yeah. So anyway, I think where I heard Ray say we can't hear you was just as I was about to talk about the common sense here, and Ray was talking about the line between negligence and gross negligence. You know, we've decided we're going to let folks make in good faith mistakes and even some bad mistakes, but not really bad mistakes or worse. We're not going to protect that. And I said at the beginning when we were talking about, you know, the phase here and what we need to deal with, how the coalition that was built so well by groups led by Ray.
I think we lost you again, Chris.
Yeah, we're losing him again. And while Chris is coming back, Ray, I was going to say the exact same thing. Just how Chris kind of opened up the discussion and really framing it out for us, and striking that balance between keeping the state's economy running and also just doing what we can on the health measures. So that's
that's right, Ryan. I mean, the big takeaway here that I think sort of drove this and is driving it across a number of states now is we're doing the best we can do. You know, and that seems to be all the law should require. We will know more about what we did correctly in another 6 or 8 months from now, hopefully, right? But for now, we're doing as much as the health experts tell us and as much as common sense tells us. And so, you know, you should not be punished. The law should not punish you when you've done the very best that you can. And I think House Bill 118 recognizes that. And again, a pretty impressive vote. He gave you the vote totals. There were only 6 or 7 members in each chamber that didn't come on board. And again, so that sort of shows you there was a pretty bipartisan agreement that we deserve this kind of protection across the business community. I think it's also a neat thing to point out, since we've got a second to do it. It's everybody. It is the sole proprietor as much as it is the large, local. I still call you guys REAs, Ryan. The co-ops. It's everybody. It's the large employer, the medium-sized employer, and the small employer. So, I think that gives cover to the fact that there may be something reasonable in a congregate environment for a large employer that's frankly different in an environment for a small employer. So the beauty of 118 is it provides that sort of flexibility.
Yeah, maybe that's Chris's reference to the fine wine right there. So maybe he can work the same magic on his microphone. Who knows?
He appears to be dialing in, but I think he had a flip phone, so it may take him.
It may take a second. Ray, I was going to save this till the end, but both you and Chris have brought this up. Just I mean, coalition building is important in so many aspects of the work that we do, but it sounded like we might have either some new best practices to come out of this, or at least something to kind of reflect on. I know specifically you guys had mentioned being engaged with the educational institutions as part of a coalition, something that doesn't always happen. So
That's right, particularly for a quote business effort, right? And we're having to learn to think differently about that, because business has said, particularly in a point of particularly low unemployment prior to COVID, of course, we've had to make that connection more closely over the last few years as we look for people to fill those jobs. Ryan, I would tell you one other thing that certainly wouldn't be in my talking points, but it's important, and I'll it's also helpful when you're doing something like this to not have meaningful opposition. And I think that was notable here. There, of course, is a very well run and a very respected organization for trial attorneys, for more plaintiff oriented law firms, similar to the North Carolina Association of Defense Attorneys, which Chris has actually been the president of in the past, or the chair of the board of in the past. And so they were very reasonable in our conversations with them. That they did not insist on many changes to the legislation that would have watered it down beyond what would have been worth getting across the finish line. So, so in addition to that, having a good coalition, it helps to not have a lot of opposition on the other side, or at least to be able to have a meaningful conversation with them, such that that it doesn't end up stalling the bill.
Hey, Ray.
You're good, Chris. If you'll mute yourself on, yeah, you did it. Very good. So drive us on, brother.
Okay, terrific. Hey, folks, listen, I apologize for these technical issues, and I'm not going to mention who my carrier is here. But anyway, I'm back. So let's see where I had left off with y'all. And I hope you're not getting feedback. Ray, can you give me a thumbs up if we're good? Okay.
There's a little bit to go there, Chris. Not much. I don't know if it would help to turn your computer.
I think you also need to turn your speaker off when you're talking. Otherwise, we're going to get both your voice on the phone and your voice through the Zoom.
Yeah, so Chris, mute on your computer, mute yourself.
Oh, okay. Hold on.
And mute the noise coming from the computer too, if you can.
All right. How's that now, folks?
Wonderful.
Is that better?
Perfect.
Terrific. Okay. Thank you, and apologize for that glitch, everybody. But so, right, we've made the decision to protect each other in the situation where you stub your toe or you stub your toe badly. But we're not going to protect misconduct. And we were just about to start talking about the important next step. And I know this audience appreciates this point very much, but there's got to be, the General Assembly has acted with real clarity here. There has now got to be clarity when the courts and the lawyers address this. So I would encourage you all, and this is something that I call with Ray and my colleagues at the chamber, Project Picket Fence. And what is meant by that is we need to have a clear delineation between what's protected by this legislation in the courts and what's not. And it needs to reflect the General Assembly's intent that we let the engine run and we protect those who are operating in good faith. And that's going to be the meat of the coconut, how the courts then deal with this really very clear pronouncement from our General Assembly. So let's go to the next slide now and talk about some of the another key issue in H118. First, just a housekeeping note, this of course doesn't eliminate claims against employers for workers' compensation. The law is if somebody can show that they were injured at work, broke a leg doing their job, or actually caught the bug while doing their job, they can bring a claim for workers' compensation. This
Chris, we lost you again, brother. Did you by any chance mute your cell phone accidentally?
He's frozen on my screen. Oh, you back,
he's-
Chris?
Yeah.
I hope so. Okay, I'll keep talking. So workers' compensation claims can still proceed. And that's, the way the law always has been. But the other important component of H118 is this notice requirement that we talked about up front. And the way the General Assembly did this is to make clear that, we are, while at the same time protecting ourselves from good faith mistakes, we're also telling everybody, you've got a duty to tell people what you're doing to protect them when they come to your business. So while this notice requirement applies to everybody who's protected by the legislation, it doesn't apply to you and me in our homes. We're accepted from that, but it applies to every business across the state that you've got to give reasonable notice of the actions taken by the person for the purpose of reducing the risk of transmission of COVID-19. And in a couple slides, we're going to get to a kind of fun quiz portion here where we're going to look at some examples and talk about them, and you're going to get to vote on that. So Ray's going to quiz you in a couple minutes. But let's go to the next slide and just deal with if we could go to the next slide, please. Right. So as Ray said, targeted, temporary, and timely. Well, obviously timely because we're in the midst of the plague, right? So the General Assembly acted very timely. It is targeted. We've gone through that, how everybody's got it. And the targeted protection is, your good faith mistakes. And so long as you weren't acting with gross negligence, you're going to be protected. And then the temporary part. This is what the law says here. This law will protect you until Governor Cooper rescinds the order of emergency, the declaration of emergency, which is that executive order there referenced, 116, issued back in March. Doesn't look like that, unfortunately, is going to happen anytime soon. But once it does happen, we each have this liability protection for 180 days following that rescission. So I think that's what I wanted to cover on the meat of the coconut. Apologies again on the technical issues, but now we get to come to a little bit of fun here. And if we can advance it to the next slide, and Ray's going to tell you what we're looking at.
Chris, if I can call an audible, if you would mind, Emily, going back 2 slides, just point out again this limited immunity that Chris has talked about, reasonable notice. So you've got to show your customers and those folks coming in and out reasonable notice of what you have done, what actions you have taken to reduce the risk. So now go to the first sign, which is interestingly one I snapped at my mechanics place. I have a really good shade tree mechanic here in Raleigh. He actually doesn't work under a shade tree. He has a garage. But it's not a chain place or anything along those lines. And I walk up to drop off my car a couple of weeks ago, and I see this sign on his door. So Emily's actually going to poll you and ask you to participate. We want to know, do you believe, and you can move the poll around on your screen if you need to. You can click on it and move it. Do you believe this poll is adequate notice as required under House 118? Recall the words of the statute. You must provide reasonable notice of actions taken for the purpose of reducing the risk of COVID-19. So we'll open the vote and allow you to vote and see whether you think this is adequate or not. And Emily, I think you can see what kind of response we've had. So you turn the poll off whenever you're ready and show us the results.
Will do. We're about halfway with everybody, so I'll give it another minute, maybe 30 seconds.
People are reading it closely and remembering that tip you gave them there, Ray.
Give about 15 more seconds.
And here's just another thing that's great about the business world. I mean, just how much the business world has adapted. The number of folks that are willing to come to my house and get things to work on now is staggering. So they'll actually come get your car if they need to.
So you guys should all be able to see the results on your screen now.
Yeah. What I like two things about the results, Chris. One of them is there's definitely disagreement. We don't have round agreement that this is sufficient or insufficient. And then there's still some folks that say, I don't know. In fact, close to 30% of our audience says, well, I'm not really sure still. So, Chris, I don't remember the last time we talked about this. I felt really strongly that what Mr. Ray Weatherspoon had done here was sufficient. I felt like as a customer, I knew what they were doing. And I could make, and I think this was critical to the bill drafters, I could make the judgment as to whether this was enough or not. I know that they're cleaning and sanitizing if I have to go in and stand around and wait to pay or sit and wait to be, called upon or waited upon. I know that they're actually wiping down the door handles and the doors themselves. And I know that they've got an alternative plan that allows me to not even enter their place of business if I don't need to. Could there be more here? Could they have said, Chris, we will test our employees regularly. We are interviewing our employees every day to ask them if they have symptoms. And of course, if they do, we're asking them to go back home or to go be tested before they come back. Sure, I think there can always be more. House Bill 118 says reasonable notice. And we know, Chris, that's a legal term of art, reasonable. Feel free to disagree. It'd be better for our audience if you disagree with me, Chris.
Well, Ray, I live for that world in my place, for that word in my world, reasonable. What's reasonable? So I'll tell you what, I've got some comments on this whole thing that maybe let's go to the next slide, do our poll on that too, and then maybe talk a little bit more. And if anybody's got a question, we can do that. So, let me tell you about this next bit of this next question. So this signage comes from my favorite beer and wine store in Chapel Hill, where I've become a still more regular customer. It's called Bottle Rev in East 54. And they've got the sign up there, know your W's, your 3 W's, and that's the signage put together by Dr. Mandy Cohen's people in her department, and they've put that up there. And then we've got this nice other sign there on the right that says stop. You can, no mask, no enter. So you don't get to come into their place unless you're wearing a mask. And the fine print down there says, what is his name? Chief Safety Officer. Something like that. The guy, the skull and bones there. And you can see my car actually in the reflection there of the window. But what do y'all think about this one? Is this adequate notice as required by H118? And Emily, when you're ready to tell us post the results, pop them up there.
Give it about 20 more seconds.
Okay.
Some people have joined us by phone, so we're not getting everybody voted, but most of them, so that's good.
Okay. Okay. Let's see, we're getting some comments in on this. Yeah, so is this adequate? A little more, a number more no's there. And I get that, and credit to the people on the line and who said no, who, really read the statute closely. Ray took you back to that slide, and it says reasonable notice about what you are doing. There's really nothing in this signage here that says what they're doing. It's got the 3W sign up there. It says you can't come in without a mask. but there isn't any guidance in here about, what they're doing. Are they wiping the place down? How are they managing things? I can tell you these are good folks with a good small business. Ray would tell you that there's I think it's 900,000 small businesses in the state of North Carolina. So there's signage like this that should be going up, maybe a little bit more detailed all around the state. But I guess the comment that I would share with everybody is, we all need to show each other a little bit of grace and understanding. And this signage here would get tripped up by a lawyer for sure. It doesn't technically comply with the language that Ray pointed you to, but that doesn't mean this business or any other business will lose its liability protection, because the General Assembly was very clear that while we've got this duty to post the reasonable actions that we're taking, it does not make your liability protection contingent on either actually doing that, number one, or doing it right, number two. And that's important because you can imagine we'd sort of be back in that position that the universities and the schools were under the governor's executive order, looking at that definition of what an essential business is and wondering, my goodness, did we get this signage exactly right because our protection under the law hinges on it? And you can imagine all the fighting that lawyers could engage in over the wording of the notice that's put up. So the General Assembly was very intentional and said, listen, y'all have this duty to post this notice. And I think my friends at Bottle Rev have made a good faith effort to do that. But they're still protected even if they stubbed their toe and didn't get it exactly right. So Ray, any reaction to that sentiment?
I think that's right. I do think we can deal with the question. One person said, they would have really liked to have seen on the mechanic notice that they were wearing masks. I could argue that either way. I could argue that if we have a state law or a state mandate in place or an executive order that the governor has insisted that we wear masks, then you can infer that businesses are complying with that legal order. I could also argue that if you were having masks wearing on your property, which of course any business, good faith business right now, I think would be, then yeah, put it on your sign. So I agree with the premise of the question, although I don't know that it's legally fatal that it's not there, because again, there's a mandate already in place. And I think maybe the business is entitled to a little bit of a presumption that they are already doing what's been required by the executive orders. Just a thought.
Yeah. Well, but everybody's got the duty here to do your best and to provide that reasonable notice at your business. And, you can take comfort in that there isn't an enforcement mechanism in the law that will, that you could get in trouble with if you don't get it technically right, but everybody's got that duty and you need to do it. So I think with that, that's a good discussion. I don't see any other comments on those signs, and let's flip to the next slide. And we're coming right up on the noon hour. And I think this is probably a good point to either flip it back to Ray or to Ryan, unless, Ray, you've got any comments or questions about those signs?
No, Ryan, if you want to sort of open for questions or drive the train here, I'll certainly entertain that, or we're happy to give a couple of closing arguments. You tell me.
Yeah, I do have just I know, give you guys the chance on closing arguments. I do want to thank you both for your time and expertise today. Certainly everything y'all do and your organizations, it really makes a difference. I think and Chris's technical pause right there, we got at a couple of the questions that I was interested in earlier. I don't see any additional ones coming through the chat right there. Let me take another double look, if so. And Ray, I think you addressed some of the comments earlier.
Sure.
And Ryan, I would just mention to our audience, our economic developers and everybody involved in that out there, that your General Assembly has done a really good job and made a really good faith effort at getting that balance right, to make sure that we protect ourselves, but also give people room to keep the engine running. And that's what this legislation was all about.
Yeah, you guys have done a masterful job explaining that. The examples I really kind of, as they're intended to do, should kind of bring it to life and a real practical understanding. So I know that it certainly kind of sharpened me up a little bit. Anytime you get a question wrong, you pay more attention.
Well, Ryan, to put a point on something I think Chris hinted at the beginning of the presentation, and you all as an organization who care about economic development and the competitive business climate in the state. Unfortunately, I think Chris has accurately predicted that this may be the first several chapters in the book, but we'll wait and see how the epilogue is written. To make a long story short, this will undoubtedly end someone's claim for recovery. That will undoubtedly be appealed, and there will undoubtedly be a discussion at our appellate court level about where the line has to be drawn. And that is why, if I may just say, our engagement with you at the Chamber Legal Institute, an entity that is designed to think about that kind of thing, and look at the public policy we have at work here. We know that by a vote of about, an aggregated vote of about 150 to about 15, the legislature spoke very clearly here. It sure would be a shame if the courts took it upon themselves to nuance this or to read more into it than's needed. And so just a plug there that, again, I think brings us all together. There's a substance here, there's a social piece and a political piece, but at the end of the day, there's a policy piece that may still rear its head over in the court system. And so we got to be vigilant. We got to watch that. We got to monitor that. And I think, that's probably stealing a little bit of Chris's thunder, because I think he summarizes that well as anybody.
Yeah, that's actually perfect, Ray, and closing comments right here. Chris, jump in if you want to, but I did want to make that point to our members and other guests that are out there, just how active the chamber is. And I know y'all know it, but if you haven't looked at the strategic plan from the chamber, I encourage you to do so. I mean, just in the past few years, a really impressive list of legislative accomplishments, and most of which are very near and dear to the things that impact our profession each and every day. Our business rankings, strong education workforce, all those different things. So if you haven't taken a look at it, just Google the Chamber's new strategic plan. I think it's really informative, and also help our organizations continue to work together closely as we advocate for the things that we need to keep our state strong. So, Chris, unless you got anything else, I certainly want to thank our sponsors here, everybody that joined the call today. Both you and Ray have been phenomenal. Just really quick, you guys, you should have received an email earlier this morning for the annual conference next week. That's Wednesday, August 26th. If you hadn't seen it yet, it should be in your email. Got a little bit of update from Liz there on 2 of the site selection consultants that have committed and will be a part of the panel. Some familiar names and faces there for you guys. Additional details on the website, of course. In the meantime, stay connected, stay confident, and stay cool, folks. The summer lingers on, but anything else, Chris or Ray, we can rest our peace, and maybe the weekend's a step closer for Chris's fine wine out there.
Thank you all very much. Enjoyed it.